Let's go on the record. This is case number 08C01-2210-MR1, caption State of Indiana versus Richard M. Allen. Are you Richard M. Allen?
Yes, Your Honor.
Mr. Allen appears in person in the custody of the Sheriff of Carroll County. We're here for an initial hearing in a criminal proceeding. Mr. Allen, we're not here to determine any questions of fact, we're here to explain to you the charges to which you're responding to, the statutes under which you're charged, your rights to an attorney, and your constitutional rights. Before we get to any of that though, the court notes that on today's date the state of Indiana filed a verified request to prohibit public access to a court record, and the court also, in response to that petition, filed an, or entered an order, which can be found on the docket, court order sealing request in court records pending public hearing. There are a system of rules called the Indiana Rules of Court Rules on Access to Court Records, and Rule 6 allows for the request to seal records and the records themselves to be sealed pending a public hearing, and so the court has granted the temporary relief and scheduled a public hearing on November 22, 2022, at 9 a.m. to determine if the Rec-Stead court records should be restricted from public access as requested by the state of Indiana. The state of Indiana has the burden of demonstrating that it's entitled the relief it's seeking, and the state of Indiana has to post a public notice in compliance with the Access to Public Records Act, and the court date and time for that hearing should allow for the notice to be posted in 20 days to pass, which is required under the rules. That covers some preliminary matters that are atypical. The rest of the matters are fairly typical. Mr. Allen, if you'd raise your right hand to be sworn. That's all right. Is he? Okay, I see it. I suppose it's worth noting for the record it does appear that maybe you have some protective gear on.
Yes.
I don't own a bulletproof vest, but it looks like a bulletproof vest and some other things, and so the court notes that the defendant is in custody and there have been extraordinary matters taken to protect the individual. We're here for an initial hearing. Mr. Allen, do you read and understand the English language?
Yes.
What is your age?
50.
What is your date of birth?
9 out of 9 of 72.
What are the last 4 digits of your social security number?
Indicates.
What is your current valid mailing address, if you have one?
1967, Whiteman Drive, Delphi, Indiana, 46923.
Are you under the influence of any drug, including alcohol, at this time?
No, sir.
If, at any time, you do not understand anything I say, will you, please, let me know?
Yes.
You're charged in Count 1 with murder, a felony. Count 1 alleges that on or about February 13, 2017, in the county of Carroll, state of Indiana, Richard M. Allen did kill another human being, to wit, victim 1, while committing or attempting to commit kidnapping of victim 1. Without admitting to the allegations contained in Count 1, do you understand the allegations contained in Count 1?
Yes.
Count 1 charges you under Indiana Code 35-42-1-1. This statute provides, in relevant part, a person who kills another human being while committing or attempting to commit kidnapping commits murder, a felony. Do you understand the statute under which? Do you understand the relevant portions of the statute under which you're charged?
Yes.
You're charged in Count 1 with murder, a felony. A person convicted of murder in Indiana may be sentenced to a term ranging from 45 years to 65 years, the advisory sentence is 55 years, and the fine can be imposed not to exceed $10,000. Do you understand the range of penalties for a person convicted of murder?
Yes, sir.
You're charged in Count 2 with murder, a felony. Count 2 alleges that on or about February 13, 2017, in the county of Carroll, state of Indiana, Richard M. Allen did kill another human being, to wit, victim 2, while committing or attempting to commit kidnapping of victim 2. Without admitting to the allegations contained in Count 2, do you understand the allegations contained in Count 2?
Yes.
Count 2 again charges you under Indiana Code 35, January 1, 42. This statute provides, in relevant part, that a person who kills another human being while committing or attempting to commit kidnapping commits murder, a felony. Do you understand the statute under which you're charged in Count 2?
Yes.
Count 2 charges you with murder, a felony. A person convicted of murder may be sentenced to a term ranging from 45 years to 65 years, the advisory sentence is 55 years, and a fine can be imposed not to exceed $10,000. Do you understand the range of penalties for a person convicted of murder?
Yes.
Those are the two offenses to which you're responding to in this action. We'll now go over your rights to attorney and then your constitutional rights. As you have the right to retain and be represented by an attorney in this case. You also have either right to proceed without an attorney if you so desire, and if you do not have the money, means, or property to hire your own attorney, an attorney will be appointed to represent you potentially at no cost to you. So there are three choices, only two differences. The three choices are hiring your own attorney, being your own attorney, or being examined to see if you qualify for court-appointed counsel, and so two of those, you still have the services of an attorney, one you hire yourself, the other the court appoints, and the third being you serve as your own attorney, which I've got 3 pages of dialogue I have to read to you.
Sure.
To explain how foolish that is before I can allow you to do that, but I also must allow you to be foolish if you have your mental faculties and that's your choice. Do you understand your attorney rights, Mr. Allen?
Yes.
And do you wish to be examined to see if you qualify for court-appointed counsel? Do you wish to proceed as your own attorney, or do you wish to have time to see if you can hire an attorney of your own choosing?
I wish to hire an attorney of my own choosing at this point.
You must retain counsel within 20 days, 2-0, because there are deadlines for filing motions and raising defenses, and if those deadlines are missed, the legal issues and defenses that could have been raised will be waived or given up. Do you understand that?
Yes, sir.
When the court found probable cause to support the charging information, it set bond at $20 million cash or corporate surety. This is the first time anyone's heard that, the state included, and so that's what bond has been set at. Defendants indicated a desire to hire an attorney, which is defendant's choice. We'll now go over the constitutional rights and then we'll set the matter for omnibus hearing and jury trial. Your constitutional rights are as follows. Mr. Allen, as a defendant charged in a criminal prosecution, you have certain legal and constitutional rights guaranteed to you. You have the right to a speedy public trial by jury in the county in which the offense was allegedly committed, and the court is scheduling that trial for March 20, 2023, 9 a.m. as a first setting. Did you get that date in time, Mr. McClelland?
Yes, Your Honor.
And since it is a first setting, March 20th, 2023, the court is setting an omnibus hearing for January 13th, 2023, at 9 a.m. The omnibus hearing is tethered to those deadlines that were referenced previously, Mr. Allen, and so counsel certainly must be retained before the omnibus hearing to meet those deadlines, and if you can retain counsel for financial reasons, notify the court at your earliest opportunity in writing and you'll be examined to see if you qualify for court-appointed counsel at the court's earliest opportunity. Your constitutional rights are as follows, or continue. We talked about the trial that you're entitled to and it's been scheduled. You will be presumed innocent unless and until the state proves you guilty beyond a reasonable doubt. You have the right to face all witnesses against you and to see, hear, question, and cross-examine those witnesses. You have the right to require witnesses to be present at any hearing to testify in your behalf and, at your request, subpoenas will be issued by the court requiring witnesses to appear on your behalf. You have the right to remain silent and you cannot be required to give any testimony or make any statement against yourself to anyone. You have the right to be heard in your own defense at any hearing or trial concerning the charges against you. Anything you say, however, may be used against you. Do you have any questions concerning any of the rights that I've advised you of?
No, sir.
Upon finding probable cause, the court set bail at $20 million cash or corporate surety. Bail is permitted, even in this type of case. To preclude bail, the state has certain burdens to meet, although initially we could set a no-bail hold subject to review, I suppose. Does the state wish to be heard regarding the issue of bail or release at this time, Mr. McClelland?
Judge, the state is orally going to move the court to consider putting a no-bail warrant on Mr. Allen or consider holding Mr. Allen with no bail. I can follow it up with a written motion, if the court prefers that, but I am orally moving for the court to consider that, Judge.
The court set bail upon finding probable cause, in case the defendant was unable to be brought before the court for an initial hearing, and that has occurred. The court is going to order defendant held without bail pending a formal bail review hearing, likely with the assistance of counsel, and so you've been explained your attorney rights, Mr. Allen. Pending omnibus hearing or further bail review hearing, you are going to be held without bond, and the issue of bond can be brought before the court by written motion by either an attorney of your choosing or court-appointed counsel, if you qualify, if you are unable to hire an attorney of your choosing. Do you understand the process?
Yes, sir.
Okay. We've got a trial date, we've got an omnibus date. If you're unable to hire an attorney, notify the court in writing and we'll have a similar hearing as we had today to see if you qualify for court-appointed counsel, and then, if you do qualify, we'll address the issue of bail at a formal hearing, but everything is one step at a time in all cases, and even this case. Do you understand that?
Yes, sir.
All right. Anything further today, Mr. McClelland?
No, Your Honor. Thank you.
Okay. That'll be the order of the court. We've got the hearing dates and times. You're ordered to appear as ordered, Mr. Allen. That concludes the initial hearing. Thank you.
Thank you, Judge. This concludes the proceedings at initial hearing conducted October 28, 2022, in this cause.